unabashed,
the most unpredictable,
becomes a headline,
the most volatile,
outrageous behavior,
unsubstantiated narratives, a battle of personalities.
Welcome to Grand Tamasha, a co-production of the Carnegie Endowment for International Peace and the Hindustan Times. I'm your host, Milan and Rahul. This August, India's parliament passed a landmark piece of legislation known as the Digital Personal Data Protection Bill. The bill provides a framework for the protection of users' personal data and the privacy of individuals. The passage of this bill marks the culmination of a decade-long effort to frame a data privacy law, an effort that has had many twists and turns. Our guest on the show today has been intimately involved with this effort as a lawyer, as an author, and as a technology expert. My guest on the show this week is the lawyer and author Rahul Mathan. He is the author of an important forthcoming book, The Third Way, India's Revolutionary Approach to Data Governance. He has been working on and following the Personal Data Protection Bill for quite a long time. Since 2016, he has written a weekly column for Mint called Ex Machina and hosts a podcast by the same name. It's a pleasure to welcome Rahul on the show for the very first time. Rahul, great to see you, and thanks for coming on.
Lovely to be here. Thanks for having me, Milan.
So there's a lot to cover, but maybe we just start kind of where we are today. You have been waiting for a data protection law for over a decade. You point out in something you've written that it's been something of a kind of inside joke at various international roundtables and conferences because you keep saying, "Oh, it's around the corner," and then it never really quite has happened until now. Maybe we could just start with the very basics. What is this law? Why do we need it? Why is it so vital? And what is it meant to do in the kind of broadest possible terms?
So thanks for that introduction. Actually, every time I go to one of these international privacy conferences, I stand up and say, we will have it next time. And I don't know what I'm going to do when I go to these conferences. My shtick is gone, and no one's going to laugh at my introduction anymore. But it's as a law, India is one of the last countries to put in place a data protection law. Certainly, the last country of its size, and the last country which is so heavily digital. And in that's the reason why we've been waiting for a really long time for something like this, because it sort of fills a much needed gap in the jurisprudence. So what is a data protection law? Essentially, it's a law that protects personal data, and it offers individuals certain rights over their data, and also prescribes the manner in which people who collect that data, process that data, store that data, use that data, have to deal with the data. And every country in the law has it. Most famously, Europe has got GDPR, the General Data Protection Regulation. I think certain states in the US, California, notably, have a law like this. And almost every country in the world has a law like this. And when you think about India, which over the last decade and a half has digitized all aspects of its functioning in such a remarkable way, it's almost inconceivable that having invested so heavily in population scale systems that collect data for the benefit of people, that they haven't at the same time put in place a regulation to protect the misuse of that data. And so it's absolutely necessary. I think you mentioned that I've been doing this for a decade. When the very first element of India's digital public infrastructure was created, that is Aadhaar, the identity infrastructure, I remember having a conversation with Nandan Nilekani, who was the sort of the technocrat who was putting it all together. And I said, this is wonderful, this thing that you're doing, but you should put in place a privacy regulation, because that's sort of the flip side of what could happen as a sort of a malevolent side effect of what it is that you're doing. And to his credit, he immediately said, yes, we should. And that's how that whole process started. But for all sorts of reasons, it's taken over a decade for us to have this law.
So actually, I want to just pick up on that for a second, because the very first draft of a data protection law that you worked on was back in 2012, when the government was looking to establish some kind of privacy framework to support Aadhaar. As you mentioned, this unique biometric ID program has something like 1.3 billion enrollees and counting. Just tell us a little bit about your own personal journey. How did you get involved, and where did that Aadhaar related effort take you?
So I have been a technology lawyer and by association a privacy lawyer for over 2 decades. And when India's digital identity program was conceptualized, it occurred to me that we needed to put something like this in place. And because I knew Nandan, I had the opportunity to speak to him and tell him that this is necessary. And we worked on this initial draft. No one's ever seen this draft because even though we put it together for various reasons, it's too detailed to get into, perhaps not even relevant at this point in history. It never saw the light of day. Governments changed, priorities changed, and we had several versions of the law after that. We had several committees that were set up to look into this. I mean, I would even say that the global reality of data changed, because when we created Aadhaar, it was in many ways before big data, and then after that, big data happened, and then we started seeing the real effect, the real population scale effect of how personal data could be misused. We saw things like Cambridge Analytica. We've seen all sorts of global examples of how data at this scale can be misused. And I think all of that, if played into the evolving nature of the various drafts that came out. And in many ways, the drafts reflected the latest issue in the specific wording. And so, I was involved in preparing that first draft that no one's seen, that went nowhere. And then I've been very actively involved as a participant in the many consultations that the government and the various committees have held on every other draft that has come out. And so, quite frankly, I've seen this painfully every step of the way. But very happy that no matter how many twists and turns it took, no matter how delayed it got, that we're finally here and we have a law that I think is a good law for what we need at this stage in the country.
So let me just ask you about one of those important twists and turns. It was during the Aadhaar case before the Supreme Court that the government, in its submission, assured the court that it would enact a comprehensive data protection law that kicked off a series of events, beginning with the setting up of a committee under the former Justice Sri Krishna. That committee deliberated. It emerged with its own draft law. It was incorporated into the government's bill. Now, that was introduced in Parliament to much fanfare, but never saw the light of day. Tell us a little bit about that effort, its framework, and what happened to it. Why did it never come to pass?
So I think we got to see it in the context and the time when it happened, right? So the Justice Sri Krishna committee was deliberating on a draft at about the time when GDPR had been enacted, before it came into force, but when it had been enacted. And so they were thinking about a data protection law at a time which was, very much influenced by this right to privacy judgment that had just been issued by the Supreme Court of the country on 9 judge bench, the largest gathering of judges in the Indian Supreme Court to deliberate on an issue of privacy, and also what was happening around the world, which was GDPR in Europe, this whole big data movement. Everyone was seeing the consequences of having vast amounts of data, and so I think it's fair to say that the Justice Sri Krishna draft was a much more complex and comprehensive version of the draft, much more aligned with the GDPR way of doing things than the first draft that I'd worked on. And then every iteration, and as you know, the draft, first of all, there was a lot of consultation for the draft. And then after the draft came out, a lot of people were unhappy with what the draft said. And so before the government presented it to Parliament, they actually went through a whole set of other amendments, and then finally it came before Parliament, and then there was a joint parliamentary committee that was created that looked into all sorts of other things. So that the third draft that came out of the joint parliamentary committee, quite frankly, was like a quilt of different intentions. Various people had mentioned concerns that had to be addressed, and a lot of those concerns were certainly in the final draft, but were discombobulated. They didn't sort of were internally incoherent. They were not they didn't work well. And some of us who've been waiting for by that time a long time were like, look, we'll make it work. But heart of hearts, we were like, this is going to be really difficult to operationalize. And so towards the end of it, I think as much as I was disappointed that we were not going to have a law at the end of that parliamentary session, I was secretly relieved that we weren't going to have this really cumbersome, almost Frankenstein of a law with pieces put together based on different intentions. And it was finally withdrawn from Parliament with a promise to put in place a newer, simpler law. And so that's sort of how we got to 2022, which is when the most recent draft was introduced for the first time.
And so this is a good place to maybe pause and ask you to reflect on the bill, which is now an act of parliament. You wrote that you experienced these twists and turns. You had the promise of a quite comprehensive, maybe too complex Sri Krishna bill. Then you had a JPC bill, which was a bit of a patchwork, as you mentioned, a Frankenstein. But then you noted that when the government finally unveiled its law, which is the law that has in fact been enacted, you were pleasantly surprised. Tell us why.
Because quite frankly, this was a much, much simpler law. And I think I have gone on record, even with the Justice Sri Krishna draft, to say that for India's stage of expertise and experience with data protection, even the Sri Krishna version was too complex. I think we've got to recognize that GDPR came after 20 years of European experience with data protection, and they had all sorts of regulatory institutions in place, all the organizations, the companies within Europe had internal operations, technologies in place to be able to deal with the demands of such a complex law. India, on the other hand, had none of this. We didn't have a regulator. None of our companies had any experience with complying with this sort of a burdensome law, except to the extent that they had operations abroad, and even then they would do whatever they could to try and wriggle out of the onerous obligations. So in that context, if we were going to implement a law which was as burdensome as the GDPR from scratch, I felt that it was going to be too much of an ask. And so with every additional complexity and new compliance burden that was placed with every subsequent version, I was getting more and more concerned that this was going to be unworkable, which is why when the final draft came in 2022, I found a much simpler principle-based regulation that, after the consultations in the most recent 2023 version that has been tabled and passed in Parliament, has, if anything, been even is simplified even more. I think that this is probably appropriate for the current stage of Indian data protection jurisprudence and even experience. And I think this is something that companies will be able to comply with very easily. And I have no doubt that there will be that we will have to ratchet it up. We will have to impose additional obligations because it's too simple. It doesn't deal with all of the things that GDPR deals with. But I think that at this particular stage of our evolution, this is what we need. And I hope that we will be able to use this as sort of a starting point to gradually ramp up the complexity if required, but also move it in directions that are not weighed down by the baggage of all the things that have happened in the past. I mean, if you look at GDPR, I think in many instances it's not well equipped for the generative AI present and future that we find ourselves in. And a simple law like the Indian law has none of that baggage. It could well chart a completely different path that would not only take advantage of all that AI has to do, but offer different ways in which to protect against the harms that AI can cause.
So as you know, Rahul, there have been a lot of voices which have expressed concern about this new law. And you've written recently that you were surprised a bit by the kind of unrelenting pessimism that has followed the enactment of this law. And I just want to quote from a recent piece in which you said, it was as if the tech policy community had created a vision of what an ideal data protection law ought to look like. And since the draft we got did not concur with that vision of perfection, they took it as a personal affront. I want to get into some of the specific concerns that skeptics have voiced, but before we do that, I mean, do you think this is a case where observers and experts simply had an unrealistic expectation about the messiness and the compromise that most policymaking processes are kind of burdened with?
I don't want to, make allegations with regard to any individual or the community, but I think the fact is that the Justice Shri Krishna draft and the JPC draft, I know that a lot of people have started saying that this is too complex and that this is too burdensome. And then the most recent 2022 draft, when it came out, people were saying this is too simple. And when I wrote that piece, I was sort of feeling that we are never going to be satisfied with the perfect draft. And that is, as you say, the messiness of policy making. At the end of the day, any policy has to tread a line between, in the worst case, two extremes, and in the best case, even people that are fairly aligned with where they want to get to, but have different ways of getting there. And I think that as we go through the policy making process, I think it is incumbent on us to do our very best to present the point of view that we think is the most appropriate, given everything that we have within our contemplation. And but at the same time, recognize that there are many people like us that are similarly making their case, and it is impossible for anyone who essentially has only one way, one path to choose, to find a path that meets the requirements of every single person that's got a demand. So after having stridently made our point clear, if it so happens that that is not accepted, I think that once the law is passed, we've got to now shift focus to how to work with what we have, because that is the reality of where we are right now. And I think there's still a lot that can be done, even if, and to be completely clear, there are many things in the law that I would not I would have preferred were not there, but they are. And now I just have to work with that and see how best we can proceed with the law that we have.
So let's get into some of the specific concerns that people have raised. And maybe we should start with this question of an exemption for the government. Some critics have argued that the law as passed empowers the central government to exempt itself from any or all provisions in the interest of national security when it deems fit. Many critics worry that this could be violative of the fundamental right to privacy. How well-founded are these concerns, do you think?
So the law does allow this. So I think that if you were to, castigate the government for putting in place a provision that could allow it to do this extremely violative act, I can't say that it is not possible. But has the government done it? Would the government be able to get away if the government does? I think we're going to have to judge each instance on the basis of what the government actually does. And at this point in time, other than the risk that it could be done, there's no evidence that, in fact, a violation has taken place. And so I'll reflect on two things. One is that every data protection law has a set of exemptions. It is just the nature of data protection that, for instance, for investigating a crime, you can't expect law enforcement to ask for consent before collecting information as part of an investigation. Of course, if that law enforcement authority misuses that information to, I don't know, persecute someone, that would be bad. That would be wrong. But because of that, you can't not allow the exemption. And every data protection law around the world has similar exemptions. A second thing is that in the right to privacy judgment, there's a very, very strong overarching test, the fourfold test that applies to every government action when it comes to violating the right of privacy of an individual. And that, regardless of what is written in the law, would apply. And so, as far as I'm concerned, yes, there is a provision in the law that offers an exemption. But if that provision is misused, it isn't that we don't have a recourse. We absolutely do have a recourse, and that recourse is sacrosanct because there is this 9-judge Supreme Court bench that allows us to avail it. I think there is a concern that a lot of people have raised, which is that the Indian court process is so difficult that might be too late. That, oh yes, of course we have, but by the time we go to the court and we get all of this, all our rights would have been violated, and we shouldn't have it in the first place. But you have to balance with that the very legitimate need to actually have some of these exemptions in order to avail the societal need for law enforcement and things like that. The one final thing I'll say in this connection is I think the real problem is that perhaps we don't trust that our government is going to be responsible in the manner in which it avails these exemptions, and that in other contexts that these exemptions have been viewed more charitably because there is perhaps a greater faith in the way, in the fact that the government will not act in an arbitrary fashion. That is what it is, and I would say that it is impossible to really get that trust without actually demonstrating it through a bunch of different actions. But as far as the need for an exemption is concerned, I can't think of any circumstance where we can have a data protection law without some sort of exemptions built in this manner.
Let me just ask you about another criticism that I've heard, which is that the bill doesn't do enough to regulate the risks of harm that may arise out of the processing of personal data, right? Which is something actually previous iterations of the bill have considered more fully. Why do you think these provisions dropped out of the final version, and how serious of a drawback, is this withdrawal?
So the use in the previous version, and look at the most recent version before the one that was enacted, actually had a fairly long definition of harm. But when you looked into the actual body of the law, where it was used was in relation to harms caused to minors, harms caused by significant data fiduciaries, which is essentially really large social media type companies that process large volumes of data or that affect large sections of the population. But beyond that, there wasn't really too much of a reference to harm. And when you looked at the definition of harm, see, the problem with harm is it's just such a broad term that as you try to define the contours of harm, you start getting into all sorts of tying yourself up in knots in terms of, something it could be harmful, but in other contexts, it's absolutely essential. And as we worked through this in the consultation, it was quite evident that that sort of an approach would not really be beneficial in the context. So, I think where we've ended up as far as harms are concerned in this draft is it's not like we don't have it. I think when you look at the processing of children's data, there is a provision which talks about ensuring that a data fiduciary will not do anything that would have a detrimental effect on the well-being of a child. And we have similar provisions with regard to significant data fiduciaries. It's just that definition, that really cumbersome definition. And once again, this is another thing that with every iteration of the draft, of the draft law, got more and more complex. People were adding all sorts of things. We've got to cover reputational harm. We've got to cover financial losses. It was becoming a really unworkable approach to this. So, I mean, I agree. I think, we've got to think of harms at all times, but I don't think this current version of the draft loses that much by not explicitly calling it out. I think there's enough in there to give us a cause of action if in fact harm was caused.
Hey, Grant the Masha listeners. Thanks for listening to the podcast. Putting this show together each week is a labor of love, but it takes a lot of work to put out a great show every week. If you'd like to support the work we do at Grant the Masha, please visit ceip.org/donate. Don't forget to subscribe to us on Apple Podcasts, Google Podcasts, Spotify, or on your favorite podcasting platform so you'll be the first to know when a new episode rolls out.
Let me just pick up, Rahul, on the issue of minors. You yourself have identified one concern about the present law, which is the requirement of parental consent for everyone up to the age of 18. And in your writing, you have worried aloud that we may live to regret that provision. Tell us a little bit about how this provision works and why exactly it troubles you.
So I think there's two things. One is, if you say that you need to give special consideration to children, you need to define what a child is. And I think there's no argument in anyone's mind that we do need to give special consideration to young children who do not have the capacity to understand what they're doing in a digital context, and so could be manipulated into doing things that could potentially harm them. But the question is, at what age? And in most jurisdictions, we don't take the age of majority as the cutoff. We think of other ways to think about it, and there's usually graduated consent from 15 to the age of 13, and anything under 13, in some cases it's 10, is considered. Yes, you absolutely need consent. You need verifiable parental consent. So by setting the bar at 18, I think, in some instances, we're doing a disservice to our teenagers who perhaps may even need some sort of privacy from their parents as they work through, various issues that teens have, and that could, in a sense, have its own challenges. But I think the other concern is the way in which the age verification has been described. It's a fairly absolute framing of it, and as far as I can see, the only way that companies can comply with something like this to ensure that they're serving children above the age of 18 is to get some sort of age verification, which would be proof of identity, and quite frankly, that breaks the way the internet works. Right now we just get onto the internet. We don't provide our identity information before we access a website or something like that. But now, and once again, it depends on a lot of the rules and regulations that will come. It's possible that we will see some kind of leeway provided to companies with regard to this. But if everyone has to prove that they are not a child in order to access a site, the only way that we could do that is through some sort of government identity or something like that. And that's the worst possible scenario to build up in our heads, that in order to just surf the internet, we need to provide ID. Gosh, that would be a horrible dystopia.
I want to ask you about something else quite large that did not figure into the bill, and these are the provisions around data localization. So some of our listeners may recall that the Indian government has previously presented data localization as a way of boosting domestic growth, but also granting law enforcement agencies with access to data for law enforcement investigations. Among many in industry, these provisions set off alarm bells. They were a big topic in a lot of conversations, for instance, in the kind of U.S.-India, business corridor and channels. Are you surprised that these provisions didn't make it into the final bill? And what would you say were the reasons for that?
I'm not really surprised. So, I mean, I think when the concept of data localization was introduced in 2018 in the Sri Krishna draft, it was the most, shall we say, strict version of data localization that we have seen. Ever since then, each subsequent draft has diluted it. And so if you follow the trend lines, it seemed quite clear that it was eventually going to go down to zero. So in the Sri Krishna draft, it was all data was localized with some additional provisions for critical data. Then in the 2019 draft, it was just sensitive personal data. The JPC draft diluted it even further. The 2022 draft essentially said that we'll have a schedule with the countries to which you can't transfer it, And I think it was at a Carnegie event that I went on record to say that that's going to be a blacklist, not a whitelist. It's not going to be, there are only these countries to which you can transfer data. It's more likely to be there are these three countries to which you can't transfer data, and we all know which countries they are because India is in a geopolitical reality where it needs to keep these sorts of restrictions in place. But the with each successive draft, as you saw these provisions being loosened, I think it was quite evident that the government of India realized the reality of the flow of data in the modern economy, and they really didn't want to jeopardize that flow. I think India is very heavily dependent on it's not an island. It's very, very heavily dependent on all its trading partners, its neighbors, and things like that. So to me, it was not a surprise at all that this would go out. What was a surprise was the fact that it was introduced in the first place, because I think you're right. I think this was a sort of a knee-jerk reaction for law enforcement. They wanted access, and I kept telling the government, you're confusing the need to have access to data with the need to actually locate the data in a particular place. And these are two completely different things. You should really work on finding the solution to access, and you can achieve that access without necessarily having the data in your control. Quite frankly, having the data in your control doesn't give you any greater access to the data if you don't have a way to convince the data center which is hosting this to find a way to decrypt the data, or do other things to provide you reasonable access to the data. And I'm glad that they've realized that, and that those provisions are gone, because as you said, those were very, very worrying to companies that even since 2018 have been increasingly depending on the cloud for a lot of their services. It was just unnecessarily complicated.
So, Rahul, before we talk about kind of next steps in the future, I'm just wondering if I could ask you to reflect a little bit on the evolution, not in the bill or in the lawmaking or in the fine print, but really in kind of how this technology community has changed. Something you wrote recently struck a chord with me, where you wrote that one of the unintended but utterly delightful side effects of having had to wait so long for the law to become a reality has been the emergence of an active, articulate, and well-connected technology policy community. And, I don't think this is something that others have really commented on. Tell us a little bit about what this community looked like back in 2012, a decade ago when you first got involved, and what does it look like today in 2023?
Well, it's very simple. When I first got involved, there were two of us, literally just two people who were on opposite sides of the spectrum, were sort of slugging it out, and go out after that and buy each other a beer, kind of a thing, right? So, it was essentially very, very small. But over the years, I think, with the consultations, just with the fact that, we've had this huge right to privacy judgment, we've had, a lot of conversation around not just data protection, but all of the other ancillary provisions. We've got content moderation, we've got a lot of technology, internet shutdowns. There's just a whole lot of things that are happening in and around the digitization of the Indian economy that has given birth to this really vibrant tech policy community. People from all walks of life. They're not all lawyers. They're not all technologists. There's a wide range of folks, and we meet very often. There are signal groups. There are WhatsApp groups. There are in-person meetings. We don't always agree with each other, but I think we just respect and recognize each other. We sort of know which side of the fence each of us is on. We tolerate each other, in that sort of way. But I think as a result, we've learned to listen to each other. We've we've developed some nuanced positions, and I think that's just great. I think the what would be worrisome is if that community polarizes to the point that they can't talk to each other. But and I think I may have mentioned that, made that comment in the context of the fact that the fact that the law has come out in a way that perhaps everyone doesn't agree with has caused some rumblings of that sort of polarization. But I'm happy to say that in the days since I wrote that article, as a matter of fact, we're all just the same. We're now discussing other stuff. We've gone on to how do we implement this and things like that, and it's still as productive and vibrant as it was before. So that's really great. And I think every technology space, every policy space needs to have communities like this, and I'm so glad that we don't just have those two old guys who are now a bit long in the tooth, I must say, still bearing the weight of the diverse opinions on their shoulders. It's good to have a nice diverse group of folks.
You mentioned implementation and how whatever differences might have existed in this community, people are now looking forward to implementation and how to get that piece right. You've noted in your recent writing that there is a dramatic lack of appreciation about the extent to which businesses of all kinds will need to reorient themselves to this new and fairly rigorous data protection compliance regime. Without getting into the nitty gritty, which I think is probably what fills most of your waking hours advising companies and others, I was hoping you could tell us kind of in broad brushstrokes, what adaptation are firms who are operating in India having to contemplate at the present moment?
I actually should perhaps correct myself, because I think I wrote that probably within a couple of days of the law coming into force. And we're now sitting like more than a fortnight after that. And I have to say that I'm just absolutely inundated with companies who are really concerned about this very thing. So I thought they weren't, but I think all it took is for the law to be passed for them to realize that they do need to reorganize themselves quite significantly. Look, I think the problem is that even though it's a very simple law, it puts in place obligations that companies currently do, for the most part, have not set themselves up to address. And I'll just give you one example without getting into the nitty gritties. But essentially, if you process data of any person, and by process I mean collect, store, use. If you collected it in the past and it's still there in your systems, essentially that person can come to you and ask you the question, do you have my personal data? And in the first place, you need to have in place a system that can reliably answer them, whether in fact you do or you do not. And if you don't have it, if you've got a sales team that has got this information, but the query comes to some sort of a product team and they don't talk to each other, then you may answer saying, I don't have this information, but as a matter of fact you do, and you will be in violation of the law. And so it's simple things like that. Setting your entire organization up so that you know that all the personal data that you have under your control in the organization is accounted for, so that if anyone asks the question, you can give an answer which is truthful and reflects the actual state on the ground. And then the next level of that is, if you answer yes and they say, look, can I see the data, you should be able to provide it to them. They will ask, can I update the data because you've got, I don't know, my address wrong or something like that. You should have the mechanisms in place to do that. And it's simple things like this that companies that have never had any need to answer to these questions, and not just answer, but now also put in place amendments and things like that. It's these sorts of things that I think are going to be quite difficult for companies to comply with. And then there are very India specific things. For the first time, this law requires notice and consent and all sorts of communication with customers in relation to privacy to be in all the languages in the 8th schedule of the Constitution. So 22 languages, not that much of a lift, but it's just that no one does it today. You'll have it in English and maybe Hindi and maybe locally a few languages, but now you have to provide it in each of the 22 languages. And it's quite frankly, it's not a heavy lift. Some translators are going to be making money hand over fist for the next few months, but once that's done, everyone will be in place. But companies need to be thinking of all of this, and that's sort of the reason why I was saying there are these small things that we need to pay attention to. And I think that even if you're compliant with GDPR, some of these things are different in India.
So actually, Rahul, let me just ask you something else that came to my mind when you were speaking, which is, we're talking about educating firms reorienting. What about users, right? I mean, if one travels to Europe, you're struck by every website you access. You get this pop up about a consent and which cookies do you accept, and most of us just unthinkingly just click on the first thing that we see because we just want the whole thing to go away because we want to buy our train ticket or we want to buy our thing on Amazon. But is there not a need for a process to educate ordinary Indians, about what these processes are and how they work and what their rights are and obligations?
No, absolutely. I think I think I advise companies, so a lot of my answers have been oriented towards the questions I've been receiving. But it's as important to educate users, on their rights, on all of these sorts of things. I think the sort of the interesting thing, which is sort of unique in the Indian law, is we've got this new category of institutional actor called the consent manager. The consent manager essentially is a reflection of India's data empowerment and protection architecture, which is a piece of the digital public infrastructure that India has built that manages consent. And the only reason I mention this in the context of your question is that the consent manager is required to act on behalf of the data principal, which is the individual. And so this is the first time where we've actually put in place a technology infrastructure and institutional architecture that is designed to really help individuals manage consent, manage the way in which their data is dealt with. So, I'm hoping that this institution in the Indian context is going to do some of this education. Is perhaps going to help customers think through what are the things they are agreeing to. When they're asked to provide consent for information for a loan or things like that, to help them think through these things, because that's sort of the obligation that's been cast upon them. But yeah, I mean, even aside from that, I think it is a complex world. And the only additional thing that I would say is that, as we were rolling out India's digital public infrastructure, we kept thinking Indians will not be able to understand this. A lot of India is illiterate, and so they won't be able to do digital payments. We're doing 9 billion payments a day. A lot of it is being done by people who are illiterate. If they can't read the SMS that says that money's been credited to their account, they've got a sort of a sound box that says it out to them in whichever vernacular language they choose to program it with. So, I think Indians will, and just ordinary people will surprise you with the extent to which they are aware of their rights, and what will happen to them when they provide consent. But yeah, I mean, it doesn't detract from the fact that yes, this is absolutely important. Even sophisticated people who've been doing data protection all their lives, like me, sometimes don't understand the consequences of our actions with the really complex digital transactions that we have to face every day. So yeah, I think it's absolutely important.
So, Rahul, let me just bring this conversation to a close by asking you about the future and perhaps another piece of legislation that may have some twists and turns. The government has stated its intention to release soon the draft of a Digital India Act. Just tell us a little bit about what we know about this legislation and how it might relate to the Personal Data Protection Act we've been talking about for this conversation.
So we don't know very much about this act. To the best of my knowledge, as much as people are doing consultations and thinking through what it might have, no one has seen a draft of the law. But what I understand is that this is a law that is going to replace the Information Technology Act, and many of the provisions of the Information Technology Act. Now, the Information Technology Act was enacted in the year 2000, so well before any of these things. It was sort of an omnibus law. It had within it Section 43A, which is the provision of the law that relates to data protection. There were some rules enacted under that which provided some guidance as far as data protection is concerned, but nothing more. And so, in response to the question that you had as to how it relates to data protection, I think what we're doing is already the Data Protection Act has, now that it's enacted, has revoked Section 43A, so removed the data protection provisions from the IT Act. And I think with the Digital India Act, which will replace the rest of the IT Act, we're seeing this sort of bifurcation of the law as the digital environment is becoming more and more complex. I think what the government is doing is creating regulations that deal with more specific aspects of it. So I would imagine that the Digital India Act will have nothing to do with privacy, that data protection will be entirely within the domain of the digital personal data protection law. What the Digital India Act will have is, regulations relating to content moderation, regulations relating to all sorts of other things with regard to cyber crimes and things that happen on the internet, without getting into the domain of everything that's covered under the data protection law. And I suspect that there would be other laws like this. I mean, we've got many areas that we need to regulate. There's regulation coming down the pike for OTT players, and all sorts of other amendments to the telecom legislation and things like that. So I would say that the next few years are going to be really quite interesting in India as we start to build out legislations to address all of these various aspects.
My guest on the show this week is the lawyer and author Rahul Matan. He is the author of an important forthcoming book, The Third Way, India's Revolutionary Approach to Data Governance, to be published by Juggernaut Press. He's been working on and following the personal data protection bill for probably longer than he'd care to admit. Rahul, this is a very complicated terrain. We're so grateful to have someone with your expertise and knowledge and really clarity of expression to help break it down for us. Thanks for coming on the show.
It's my pleasure. Thanks for having me.
Grant Tamasha is a co-production of the Carnegie Endowment for International Peace and the Hindustan Times. This podcast is an HT Smartcast original and is available on htsmartcast.com. You can also find us on Apple Podcasts, Spotify, Stitcher, or wherever you get your podcasts. Don't forget to rate and review. It helps others find the show more easily. For more information about the show and to find the writing we reference on this week's episode, visit our website, granttamasha.com. Production assistance comes from Nithya Lab. Tim Martin is our audio engineer, and Isabel Villegas is our executive producer. Thanks for listening, and see you next week.
This was a Hindustan Times production, brought to you by HT Smartcast.
HT Smartcast.